Thank you everyone for joining us for this webinar, the first of a three-part webinar series on international arbitration. I'm joined by my colleague Natalie Ledger, who is also an associate with Beale & Company, working in the construction and international disputes team. Together we will discuss how to arbitrate construction disputes in the current climate. As you will all no doubt be aware, most construction projects fall into numerous disputes, either during the works or following completion. We expect that these disputes will heighten in the wake of the COVID-19 pandemic crisis. Most construction contracts provide that such disputes are to be determined by way of arbitration rather than court. Arbitration is generally considered a more confidential and sometimes more cost-effective form of dispute resolution. Instead of a judge, an arbitrator, or a number of arbitrators, referred to as a tribunal, who are usually either experienced individuals from the industry or lawyers decide on the dispute. This can be either under the supervision of an institutional center who runs arbitrations, like the Dubai International Arbitration Center, or simply overseen by the arbitrators themselves, which is called an ad hoc arbitration. Another point to flag at the beginning is the difference between the seat of the arbitration and the governing law of the contract. In our experience, most construction contracts that relate to the construction of projects in the UAE have a seat in Dubai, and the governing law is the law of the UAE. Keen attention should be paid to the seat and governing law now more than ever, given different jurisdictions will likely have different mechanisms in place to deal with the COVID-19 situation. Parties should also be aware of the arbitration institution rules applicable to the arbitration to understand the scope for video conferencing and virtual hearings. In today's session, Natalie and I will cover 4 topics: when to start preparing for arbitration and the practical steps that can be taken to aid success, key considerations when nominating party-appointed arbitrators and experts, video conferencing and online tools, and how to avoid challenges to the award and when to raise them. I will now hand over to Natalie, who will discuss when to prepare for arbitration and key practical steps to take.
Thank you, Sadaff. So, at what stage of a project should a party start preparing for arbitration? After a dispute has been referred to arbitration and the claimant has filed its request for arbitration, after a notice of dispute has been referred to the engineer or employer representative, before a dispute has arisen, or during contract negotiations? Well, the answer is it's never too early to start preparing for arbitration. So what practical steps can be taken to aid success? One of the first considerations is the arbitration clause in the contract. Whilst dispute resolution clauses are often some of the last clauses to be negotiated in a contract, it's important that these clauses are given careful consideration and negotiated accordingly. An arbitration clause should clearly specify arbitration as the binding dispute resolution mechanism, make an informed choice between institutional and ad hoc arbitration. Where institutional arbitration is selected, a correct reference to the institution should be included. Different institutional centres have different rules which will govern the arbitration, and therefore parties should consider the advantages and disadvantages of each. For example, whilst the DIAC rules do not currently provide for a tribunal with the authority to award a party's cost of the arbitration, and arbitration can be costly, the cost of an arbitration administered by DIAC is significantly cheaper than an arbitration administered by the ICC, where a tribunal does have the authority to award a party its costs. As a contractor or subcontractor, you are likely to have claims against the contractor or employer respectively. Therefore, as a contractor, if you can afford it, ICC may be the preferred choice. Whereas if you are an employer who is likely to be facing claims from the contractor, DIAC may be more preferable. An arbitration clause should also cover all claims likely to arise between the parties. and cover all parties that are to be bound by the outcome of the arbitration. It should also address the number and qualifications of the arbitration and the seat of the tribunal. It should also define the law applicable to the dispute and the arbitration clause. And it should address procedural issues where necessary, including the language of the arbitration, rules on the taking of evidence, confidentiality of the proceedings, and any exclusion of the right to appeal to state courts. As a respondent in the proceedings, one of the first steps you can take in preparing your defence is to check to see if any of the claims being brought against you fall outside of the scope of the arbitration clause, and as a result, if there is any basis for challenging the jurisdiction of the tribunal. Another step that can be taken early on and throughout the course of the lifespan of a project is good document management and contract administration. I cannot stress how important it is to keep clear and accurate records of progress on site throughout the duration of the project for the purpose of making claims and ensuring that the contract is administered properly, including the timely issuance of notices. This is equally important when it comes to arbitration. Another step that can be taken to aid success is the preservation of documents. One of the first steps a party needs to take when preparing for arbitration is locating and preserving documents relevant to its claims. Once the relevant information has been located and preserved, the next step is to identify the documents which support your claim or defence. This can be a very time-consuming and costly exercise and must be undertaken carefully. Therefore, the more organised you are and the project team are, and the more up-to-date your records are, the quicker and cheaper this exercise will be. Another step that can be taken when preparing for arbitration is to consider what witness evidence is going to support your claims. For example, if you are aware that certain employees will be vital in providing factual information relevant to your claims, defence or counterclaims, it would be helpful if that individual could note down their knowledge and recollection of the relevant events as soon as possible and dig out and provide any relevant information. This is particularly important in highly complex and high-value arbitrations that may have a long procedural timetable. From experience, arbitration proceedings can take anywhere between 1 to 10 or even 20 years to conclude, leaving plenty of time for those individuals to forget or muddle the relevant facts. It's therefore essential that this factual evidence, which usually offers more flavour than documents can, is preserved. If employees keep site notebooks, it would be extremely helpful to be provided with these and retained for future reference. It would also be useful to obtain contact details from any key employees who move on to a different company during the course of a project, or to get in contact with former employees that have already moved on to see if they would be willing to provide their knowledge and recollection of relevant events if needed. Essentially, the more contemporaneous records you have to support your claims or defence, the better your chances of success. It might also be worth putting a clause in your employment contract requiring that employees and ex-employees be available to assist in arbitration proceedings in the future. Another step to aid success is to obtain legal advice. A party is highly likely to need legal advice and representation in the arbitration. Factors to take into account here are cost, budget, and the complexity and value of the claims in dispute. Obviously, it is our opinion that the earlier a party seeks legal advice, the better, even if it just relates to a discrete point. Arbitrations can be won or lost on one small point. Whilst in-house counsel should be aware and able to give you some guidance on these discrete issues, in-house counsel can often be busy, or the matter may not even make it across their desks. If there is any uncertainty over a particular issue, then you should seek legal advice at that time. Parties should not wait until a dispute has arisen and an arbitration has commenced before it seeks legal advice. In fact, we are seeing a change from our clients who tend to now approach us a lot earlier on in a project rather than waiting for an arbitration to commence. We see this as a positive change and will hopefully help clients avoid disputes at a later stage in the project. Another step that can be taken to aid success is to instruct a claims consultant or independent expert. At what point should claim consultants and/or independent experts be appointed to carry out analysis of the merits of your claims? We typically find that parties do tend to instruct claims consultants early on, as and when issues arise throughout construction of a project, usually prior to taking legal advice or considering the appointment of an independent expert. And whilst there are many claims consultants out there, some may be more suitable than others. Therefore, one of the benefits of seeking legal advice early on is being able to obtain guidance and recommendations on the most appropriate claims consultant to carry out the analysis of your claims, and in some instances, it might be more appropriate to appoint an independent expert from the get-go. Lawyers will also be able to help you set the scope of the claims consultants or experts' work, and therefore will help you to manage costs from an early stage. Another factor to take into consideration is when you should start formal proceedings. As a claimant, as much as you may want to get the ball rolling as soon as possible, particularly when your claim may be for a substantial sum, it is very important to understand what your claims are and have carried out a full review of the merits of your claims before commencing arbitration. On the flip side, as a respondent, should you just sit and wait for a claimant to start arbitration proceedings against you? Under UAE law, if a contract provides for arbitration as the preferred method of dispute resolution, then the court should not entertain claims arising from this contract. However, we are aware of some recent court decisions in which the courts completely ignored the contract's form, which the dispute has arisen from, provided for arbitration as the preferred method of dispute resolution, and proceeded to hear and rule on these claims. Therefore, if you are aware of a potential claim that may be brought against you, and there's a risk that the claimant may refer the claim to court, despite your contract providing for arbitration, maybe because it is for a low value, for example, one option might be, depending on the relevant circumstances, to preempt this move by starting arbitration proceedings yourself in order to keep the claims in arbitration. As a respondent, you should identify any potential counterclaims early on and make these as soon as possible. It's always a good idea to reserve your rights in the answer to requests for arbitration if you are not at that stage ready to make the counterclaim. This will prevent the claimant from arguing that you have waived your right to make such counterclaim later on in the proceedings. Another important point to consider is limitation. It is very important, as a claimant, prior to commencing arbitration, to check that claims that you wish to refer to arbitration are not time barred. To ensure that you commence the arbitration effectively and within any applicable time bar provision, you will need to consider any applicable contractual time bar, as well as any statutory time bar. If the limitation period is about to expire, ensure that you commence the arbitration without delay. Equally, as a respondent in an arbitration, you should check to see if any of the claims that are being brought against you in the arbitration proceedings are time barred, as this can be raised as a defence. A respondent should also consider whether any counterclaim it wishes to assert is time barred. In the UAE, the statutory limitation period for a commercial claim is 10 years. Lawyers will be able to assist you further in this respect. Another factor to be considered when preparing for arbitration is costs and any budget. Depending on the wording of the dispute resolution clause in your contract or the rules governing the arbitration proceedings, the costs of the arbitration may need to be paid upfront or according to payment schedules. Arbitrators will also need to be paid as well. These costs, often based on the amount in dispute, can be significant. Therefore, it is important that you understand all of the costs involved and set a realistic budget, including all types of costs. such as legal team costs, institutional centre costs, arbitrators' costs, the experts' costs, and any cost of translators, along with disbursements such as travel and accommodation. Having an early understanding of your case will help to set realistic goals. You should also consider whether litigation funding may be an option, meaning that you may not have to shoulder the cost of the arbitration. Interim measures should also be considered. Consideration should be given to whether you need to protect your position by applying for interim measures before the arbitration commences. In certain cases, it may be pointless to commence arbitration proceedings if, for example, certain assets of the proposed defendant cannot be secured in advance. The new UAE arbitration law contains a non-exhaustive list of interim measures which can be issued, which includes orders to preserve evidence, maintain evidence assets or funds against which enforcement may later be sought, prevent a party from doing something that may prejudice the arbitration process, and to maintain or restore the status quo of the parties pending determination of the dispute. The most common interim measure sought by parties in this region is attachment of assets to avoid the threat of assets being dissipated. An order of an attachment can either be sought from a tribunal or through the courts. If a party is seeking this during the arbitration, it may prefer to seek an order of attachment from the tribunal because the tribunal is familiar with the case and the facts and may issue such an order faster than a court. A party with a successful order can then enforce this through the court. However, a party seeking an attachment order prior to commencing arbitration proceedings can do so through the courts. So, finally from me, why should a party prepare for arbitration? Early preparation will ensure you have a better understanding of your claims and the strengths and weaknesses of those claims. The greater the understanding of your claims, the greater we, as your lawyers and your experts, will understand your claims or defence. It will also allow your lawyers and experts to spend time analysing your claims and working out the best strategy for your claims, rather than spending a significant amount of time sorting through mountains of unorganised records at your cost. Arbitrations are often won or lost on the documents. Therefore, the more familiar the team is with these documents, the greater the chance your lawyers can develop a tight and compelling narrative of your claims, and consequently, the better your chances of success. Additionally, the more organised you are, the greater opportunity there will be to obtain litigation funding. Early advice on the merits of your claim may mean that you won't have to shoulder the cost of the arbitration. This also ties into interim measures. If you've managed to obtain an attachment order for a party's assets to the arbitration early on, which can then be used as collateral to enforce any award, the better chance you will have of securing litigation funding. Further, the greater you understand the strengths and weaknesses of your claims or defence, the better chance you have of getting the right arbitrator on board. I will now pass over to Sadaff, who will explain the key considerations when nominating party-appointed arbitrators and experts, and how to avoid challenges to an award and when to raise them.
Thank you, Natalie. When a claimant is ready to start arbitration proceedings, one of the first steps is to submit a request for arbitration to the relevant institutional centre. Depending on the rules governing the arbitration, a party is likely to have to specify the name of the arbitrator that it would like to nominate at that stage. The selection of the sole arbitrator or panel of 3 arbitrators making up the tribunal is a critical component for a successful arbitration. Getting it wrong can have disastrous consequences, not only in respect of the decision on merits of the case, but also in respect of time, cost, and convenience of the proceedings. So what are the key considerations when choosing an arbitrator to nominate? Specialist arbitration counsel can usually assist here. Nonetheless, key considerations for you to think about include familiarity of arbitration practice. Firstly, you need someone who understands what their role as arbitrator involves. While it is most important for the chairperson of the tribunal, if a three-panel tribunal, knowledge and experience of the law and practice of arbitration are also of considerable importance for co-arbitrators. Expertise in arbitration practice and procedure can be as important, if not more important, than knowledge of the law governing the contract. That certainly applies to the chairperson, and practical experience in the conduct of arbitrations is an important quality for a potential co-arbitrator. When asked to recommend suitable candidates, we need to be confident that that individual will be able to generate respect from the other tribunal members and its opponents, and be persuasive during private deliberations of the tribunal. With the recent increase in virtual arbitration hearings, parties may also consider whether or not an individual is open to using online platforms, if necessary, during a hearing. Given virtual hearings is a relatively recent phenomenon for most, it may be a lot to ask of a potential arbitrator to have experience of running such a hearing. However, openness to use such a platform may be a consideration for the parties to run the proceedings efficiently. Another factor to consider is impartiality and independence. It is a central principle of arbitration that the tribunal acts independently and impartially. A tribunal that does not act impartially and independent is unable to perform its prime function of exercising good judgment and delivering a fair and enforceable award. The arbitral process is private to the parties and generally confidential. A good tribunal will maintain discretion throughout the proceedings and in its award. The tribunal should not discuss the matter with third parties, nor with one party in the absence of the other. On conclusion of the proceedings, the tribunal should not disclose details of the proceedings or its outcome. Failing to comply with these fundamental requirements may result in the challenge and subsequent removal of the arbitrator and/or the resisting of enforcement of the award. Project management skills. A tribunal must be able to plan, organize, and control procedures to achieve its goal of the fair resolution of disputes referred to without unnecessary delay or expense. To achieve this, the tribunal is required to be a project manager. In my experience sitting as an arbitrator, the ability of the tribunal to organize itself and the proceedings is critical if an arbitration is to proceed effectively. In addition, leadership qualities are referred to guide the parties and occasionally fellow tribunal members in the right direction is also very important. Familiarity with relevant business or industry involved in the dispute. The ability of parties to be able to nominate an arbitrator that possesses the relevant area of expertise is one of the major benefits of arbitration. If the dispute involves claims relating to high value and complex issues of a technical nature, such as claims for extension of time and prolongation, for example, it is essential that the arbitrator you're nominating has construction experience. If the dispute relates to a low value and simple issues of a more commercial nature, such as a claim for non-payment, construction experience is less important, but would, of course, be helpful. The arbitrator's likely disposition. If you have 3 highly recognized practitioners from the English bar with a common law training and background, deciding on issues of UAE law, they are likely to base their decision and the basis of the award on the terms of the contract, as this is what they're most familiar with. Therefore, if the terms of contract support your claims or defense, then it may be a good idea to nominate an individual who may then also nominate an individual with a similar background as chair of the tribunal, where the tribunal is a 3-member tribunal. as this will enhance your chance of success. If, however, the terms of the contract aren't so helpful for your claims, and instead you seek to rely on various provisions of UAE law over the terms of contract, an individual with civil law training and background who will be more familiar with UAE law would be preferred. And this is something you should be seeking advice from your lawyers on. Most law firms will have experience of working with various arbitrators and will be aware if, for example, one arbitrator is more of a contractor's man, who will perhaps adopt a less strict approach to enforcing notice provisions under the contract, or if a particular person is more an employer's man, who may take a stricter approach in relation to notice provisions. Language. Obviously, if proceedings are to be conducted in English, you will need a candidate with a strong understanding of the English language. And this comes back to my earlier point in respect to an arbitrator's disposition and weighing up the advantages of nominating a common law arbitrator over a civil law arbitrator and vice versa. If your case is made in reliance on specific points of UAE law, or in particular an obscure point of UAE law, and to the extent that case law in the UAE holds any weight, then a candidate fluent in English and Arabic may be more suitable so that they can truly understand the relevant UAE law provisions and judgments, rather than having to rely on various translations. Familiarity with law governing the contract. Knowledge of the law governing the contract may be beneficial, particularly where the case or significant aspects of it may turn on legal points rather than on issues of fact. The more experienced the arbitrator, the more likely they will be open to and aware of other legal systems. Availability and conflicts of interest. To achieve a good decision, the tribunal will be required to be diligent and to put in the hours. The integrity of the arbitral process will not be upheld by a tribunal that has not read the papers and mastered the case. Some arbitration laws and rules specify the time period within which the award must be issued. A good tribunal, however, will encourage the parties to agree a sensible timetable for the hearing of the case and the delivery of the award. Arbitration centers are increasingly requiring arbitrators to confirm they have the necessary availability and, in some cases, disclose current caseloads and other constraints. However experienced or competent an arbitrator is, they will be of little value to the parties if they are unavailable when needed or is unable to progress the proceedings. Some delay is, of course, inevitable when tribunal members are based on opposite sides of the globe and they must decide a large and complex dispute. However, the risk of delay can be reduced by checking on availability and listening out for word of mouth about whether the proposed arbitrators generally gives their appointments the time and attention that they deserve. Let us now look at the key considerations when nominating party-appointed experts. The use of expert evidence in arbitration is commonplace. Although a tribunal is often chosen for its specialist knowledge or expertise, the appointment of an expert or experts to give evidence on specific issues can clarify and enhance the tribunal's understanding and assist in its decision-making. A party-appointed expert is responsible for providing expert evidence to the tribunal, usually in the form of an expert report prior to a hearing, and then giving evidence at the hearing. As well as providing evidence in support of your case, instructing an expert can have wider benefits. An expert can act as a valued advisor, helping you to organize and understand the underlying factual evidence. An expert can assist in analyzing your opponent's case and identify the live issues in a case. As previously mentioned, experts can be appointed early on, before proceedings have even commenced, to assist with the formulation of claims. This can prevent meritless claims from being brought. Experts can also be very helpful in assessing the appropriate level of settlement. Where expert evidence is necessary, it is essential to select and retain the best possible expert as early as possible. Early retention is especially important where you have a pool of experts that is relatively small, such as good delay experts or an expert specializing in a particularly unique field. Because if you don't keep the best, your opponent may get there first. If the expert is instructed late in the day, not only is there a risk of not getting the right one, that is, the preferred expert may not have the capacity to accept the appointment, but the expert may not have sufficient time to review all the relevant documents to provide a detailed report. However, the biggest risk of appointing an expert late is that the expert will provide a report which is at odds with the client's case. This results in two options. You either get a new expert on board in the hope that the new expert will support the case. There's obviously no guarantee this will happen. Or you amend the case, which will have significant time and cost impact if you're allowed to do so. It is also important to try and establish whether or not your opponent intends to retain an expert, even where you think an expert is not necessary. This is because if your opponent is obtaining expert evidence on a particular issue, if that issue is contentious or materiality affects the substance of your case, it may be best to test that evidence by instructing your own expert evidence on the subject. So what are some of the key considerations when nominating party-appointed experts? The number of experts and whether they're going to joint or separate reports. You will need to consider whether more than one expert is required. Typically, you will either have a joint or separate expert for each area of expertise requiring expert opinion. Most parties opt for separate experts. However, it is likely that the arbitrators will want a joint statement from these experts. Qualification and expertise and reputation in the field is key. In addition to being satisfactorily qualified and experts in their relevant field, you want an expert that is helpful, charming, and persuasive. From our experience, it is these experts that assist their clients and increase a party's chance of success. Expert witness experience. Does your potential expert have experience of acting as a witness in litigation or arbitration or both? Have they been cross-examined before? Often the individual that will be cross-examining them is a qualified barrister of the English bar. These barristers have been trained and are experienced advocates, and they know all the tricks in the book. Therefore, it is essential that your proposed expert has some expert witness experience and knows what to expect, as any slip-up under cross-examination can result in a loss to their credibility. It is very important that the relevant candidate understand their role as an expert. An expert is not there to advocate your case. This is our job as lawyers. If an expert does start to advocate your case, either within their reports or whilst giving evidence or being cross-examined, they will quickly lose their credibility as an expert witness. Good communication skills. The expert should be able to communicate both orally and in writing with clarity and conciseness. Good experts have the ability to communicate complicated technical issues in a way that allows non-technical persons to easily understand them. Terms of appointment. The instructions to the expert and the expert's scope of work should be as detailed as possible. This will assist the expert in understanding the issues in dispute and avoid any confusion over their scope. There will always be some commercial negotiations to be had when agreeing upon fees and deliverables, but it is important that these issues are resolved satisfactorily at the outset, otherwise serious problems could come to a head at the door of a final hearing. For example, it is not unknown for an expert to threaten to either withdraw his services or exercise a lien on his final signed report until his fees have been paid in full. However, an expert who exercises such strong-arm commercial tactics would do well to consider his own predicament in terms of both his professional reputation and his duties to the court or tribunal. Availability or conflict of interests. As with arbitrators, experts will be required to be diligent and to put in the hours. An expert will need to confirm that he or she is conflict-free to take the appointment. An expert who does not put in the hours and does not know the documents will quickly lose credibility before a tribunal. International arbitration is likely to be affected heavily by COVID-19, and construction arbitrations are no exception. Parties to a typical dispute will be located in multiple jurisdictions, as will the legal representatives and the arbitrators. The unique flexibility of arbitration holds out the possibility of overcoming these challenges by agreeing to hold hearings, both procedural and substantive, virtually by telephone or video conference. So let us look at the position of this under institutional rules. The arbitration rules of most of the major arbitration institutions either expressly provide for or at least leave open the possibility of dealing with matters remotely through the use of technology, including video hearings and telephone hearings. Video hearings themselves are therefore not an entirely new feature in dispute resolution. If you look at Article 22 of the ICC Arbitration Rules 2017, which in relevant part provide, the arbitral tribunal and the parties shall make every effort to conduct the arbitration in an expeditious and cost-effective manner. In order to ensure effective case management, the arbitral tribunal, after consulting the parties, may adopt such procedural measures as it considers appropriate, provided they're not contrary to any agreement of the parties. Therefore, both the parties and the tribunal are required to be proactive in making efforts to conduct arbitrations efficiently and to agree to appropriate procedural measures to further that cause wherever possible. The ICC arbitration rules allow for both case management conferences and other hearings, where attendance in person is not essential, to be held through video conferencing or telephone. Given the restrictions on gatherings and on travel currently at play in many countries around the world as a result of the COVID-19 outbreak, parties and tribunals should be giving close thought to whether it is imperative for there to be in-person attendance. In practice, even substantial hearings involving live witness examination may be dealt with without in-person attendance by everyone involved. Likewise, Article 14.1 of the LCIA arbitration rules and similarly the DIFC LCIA arbitration rules allow for the arbitral tribunal and the parties to use video conferencing. An LCIA tribunal must adopt procedures suitable to the circumstances in discharging its duty to provide fair and expeditious means for dispute resolution, subject to the law of the seat or other applicable rules. Further, Article 19.2 of the LCIA rules specifically allows for any hearing to be held by video or telephone. The commonly used Dubai International Arbitration Center Rules 2007 in Dubai do not make mention of the use of video conferencing for a hearing. However, this does not necessarily prevent the parties from agreeing with the arbitral tribunal the use of video conferencing. Parties should, however, be mindful of potential issues with the seat of arbitration. Before agreeing to have a virtual hearing, parties must ensure that they fully consider the impact of doing so. A key question is whether a hearing held virtually is held in the place where the arbitration is seated. There is a real risk that in any subsequent enforcement proceedings, an objection may be raised on the basis that the hearing was not held at the seat and that consequently the award is not enforceable. In common law jurisdictions such as England and Wales, such an objection may get short shrift. However, this may be different in civil law jurisdictions, which place more emphasis on the seat of arbitration. If parties do agree to hold the arbitration virtually, they must look carefully at whether any such issues might arise under the laws of the jurisdiction where the arbitration is seated and where the award is to be enforced. Part of the answer will be to amend the arbitration agreement. You must discuss with your lawyers to understand your position before opting for a virtual hearing. Let us now discuss ratification and enforcement. Under the UAE arbitration law, the arbitration award is binding on parties and has the same effect as if it was a court judgment. However, before domestic award can be enforced in the UAE, it should be ratified by the UAE court. The award can be enforced and ratified directly before the UAE federal or local courts of appeal, and an enforcement order should be obtained from the court within 60 days of a request for enforcement under the law, provided that there are no grounds on which the enforcement may be denied. A party seeking to ratify an award must file an application with the courts, which is to be accompanied by the original copy of the award or an authenticated true copy, a copy of the arbitration agreement, a legal translation of the award in Arabic, if it is issued in another language, and a photocopy of the document recording the submission of the award with the court. With the outbreak of COVID-19, the onshore Dubai courts are not holding hearings for new cases, and only limited hearings are progressing for existing cases. The Dubai courts confirmed from 19th April all hearings between parties will occur electronically and utilize Microsoft Teams, which I'm sure most of us are already using. New cases are to be filed electronically. So what does this mean for enforcing your arbitral award? The UAE arbitration law does not provide a time limit within which a successful party should seek ratification of the award. So party has the option to wait and see. The risk with this is that the opponent may dissipate its assets, leaving minimal recovery for the successful party. A party can file for enforcement, but it should be prepared that there will be delay considering the circumstances we find ourselves in. Offshore courts such as the DIFC courts are conducting hearings by teleconference and video conference wherever possible for most cases. Let us now look at nullification. Where a party wants to nullify an arbitral award, it should make its application within 30 days from the day following notification of the award to the applicant. Therefore, regardless of the Dubai court's position of hearings for new cases, it is advisable for a party seeking to nullify an award to submit its application within the 30-day period. If you fail to issue the application within the prescribed 30-day period, objections to recognition and enforcement can still be raised in the opposing party's defense during an application for ratification of the award. Now, an application to nullify does not automatically stay enforcement unless the party makes such an application, and the court must decide this request within 15 days after the date of the first scheduled hearing. The UAE arbitration law sets out the legal requirements for a valid award. The award typically must be in writing, issued by the majority, signed, reasoned, and include the details of both parties and the arbitrators. The arbitration agreement, a summary of litigants' requests, a summary of the parties' statements and documents, the verdict for the award, and its grounds, and the date and place of issuance. Article 44 of the UAE arbitration law requires the tribunal to provide each of the parties with an original signed copy of the award within 15 days from the date of issuance. Given the preventative measures to combat the outbreak of COVID-19, arbitration institutions such as the DIAC and the DIFC-LCIA are closed and are not receiving hard copies of arbitral awards. In such circumstances, arbitrators and parties should consult with each other and, if possible, get the parties' confirmation on whether an electronic copy of the award, with originals to follow, is sufficient for purposes of the institutional rules and the UAE arbitration law where applicable. The UAE arbitration law sets out 8 grounds for challenging enforcement. Firstly, the arbitration agreement, that is, a lack of a valid arbitration agreement. The arbitration agreement must be in writing and be included in a contract, or as provided for under the EU arbitration law, recorded in correspondence, including emails. 2. Capacity. The party agreeing to arbitration was, at the time of execution of the arbitration agreement, incompetent or under some incapacity. 3. Authority. Where the person signing the arbitration agreement did not have the necessary authority to act or dispose of the disputed right. The new arbitration law does not remove the strict capacity requirements that apply to arbitrations in the UAE. Article 4 requires that parties agreeing to arbitrate should be duly authorized. And Article 53(1)(b) identifies any lack of capacity as a ground for seeking nullification of the award. The article goes on to indicate that the relevant capacity will be determined by the law that governs the capacity of the contracting party. In the case of a company, this will be the law applicable in its place of incorporation. In our view, to avoid arguments about capacity to arbitrate, the safest approach is to make sure that a power of attorney is in place, giving the intended signatory on behalf of the company the specific authority to agree and enter into the relevant arbitration agreement. A party could also argue that it was unable to present its defense because it was not given proper notice of the appointment of the arbitrators or the proceedings, and as a result, the tribunal violated general litigation principles. Substantive law. The award does not apply the law agreed on by the parties. Another ground to challenge could be the composition or appointment of the arbitral tribunal was not in accordance with the agreement of the parties. Or procedural requirements, that the arbitration procedures were invalid in a way affecting the award, or the award was rendered after the expiry of the time limit for rendering the award. It continues to be the case that a party can have an award nullified if it is not rendered within the prescribed time limit. The arbitration law provides that a tribunal shall render its award in the time limit agreed between the parties. Absent an agreement, the arbitral award is to be rendered within 6 months from the first hearing of the arbitration procedure. The tribunal can extend this time limit up to 6 months unless the parties agree to extend it for longer. With the outbreak of COVID-19, many arbitral tribunals may unsurprisingly seek to extend the time limit to render the final award. It is advisable such extension is sought in accordance with the rules and law applicable and where required with the parties' agreement. Scope of the arbitrators. That is, the matters not contemplated by or not falling within the terms of the arbitration agreement, or it contains decisions on matters beyond the scope of the parties' submissions. Other challenges that we see that are often raised in enforcement proceedings include jurisdictional issues. That is, whether any preconditions to arbitrate have been complied with. Therefore, if the dispute resolution in your contract provides preconditions to arbitration, such as a process of amicable settlement, then this process must be carried out in accordance with the relevant term of the contract. Failure to do so could leave you exposed to jurisdictional issues being raised. Most tribunals will find that they have jurisdiction to rule on any jurisdictional challenge raised, mainly as they want to have the experience on their CVs and for the money. But there is a chance that the courts will rule that they didn't have authority. Therefore, this goes back to our earlier point about getting your notices right from the beginning and ensuring that the terms of any dispute resolution clause are followed to the letter. Another common challenge we see is around public policy issues. The court has the ultimate discretion to decide whether or not the award contravenes public policy, and if so, it will be considered invalid. The inclusion of a general provision that awards may be set aside if they contravene public order or morals of the UAE is understandable, not least because it is a ground in most, if not all, international arbitration laws. This ground has been used in the past as a catch-all provision to justify numerous grounds for challenge, and it remains possible to bring such challenges under the UAE arbitration law. It is important to note that the available grounds for challenge under the UAE arbitration law do not permit any review of the core legal or factual basis for an award, limiting the review to procedural and jurisdictional aspects of the award. We hope from today's session you're able to take away certain key points, which include: start your arbitration early. This cannot be emphasized enough. 2. Bear in mind key issues when nominating your arbitrators and experts. You're spending a lot of time and money into the exercise. You want to get the best people on board. 3. Consider the use of video conferencing and relevant arbitration rules and any issues with the seat of arbitration. And consider the new ways of filing enforcement and nullification proceedings with the outbreak of COVID-19 and possible grounds that may be raised to challenge the award. We look forward to your questions. Do join us for our second webinar on 2nd June, where we will discuss arbitration best practice, preparation, and funding. On a final note, we provide a virtual in-house service to our clients where you have access to any member of the project's team. This can be agreed on a fixed fee basis for discrete work, a monthly retainer at a discounted rate, or at a competitive hourly rate. Please feel free to get in touch with us. Thank you.